Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. This is Jim Santelle, and yes, indeed, I am your host this morning, as I am every Saturday morning here on the broadcast stations of Civic Media. I am delighted to have you with me again this morning on our broadcast. It is Saturday, February 17th, 2024. What a week it has been in the areas of law and government and the aspiration for justice in America. Those are the topics that we always address here on our Saturday morning broadcast. This week, no exception to that plan, to that syllabus. As always, reviewing those most significant stories, and there are many of them from just the past several days, even from yesterday afternoon. We're going to talk about all of those during the course of the next 2 hours. Delighted to have you with me here. I am in the studios of WAUK here in downtown Waukesha with my wonderful producer, Johnny. And together we're going to be talking with you about these and other issues related to our lives and livelihoods in Wisconsin, in the United States of America, and yes, also how those things affect our place in the world. What is that syllabus, and what is that all about? We're going to be chatting, as always, about three principal questions. What happened? What do we know? What are the facts of particular cases? Why are those things important and relevant? We'll be talking a lot this morning about the issue of relevance when it comes to one of those significant events from just this past week. Why are they material? Why are they significant? And what should we do, if anything, about those kinds of things? What are the appropriate actions of people who are concerned and focused upon their futures and the futures of the communities in which we live? All those things animating our very animated syllabus this morning, our agenda for discussion. And I suspect you know well the topics we're going to be addressing because they are at the top of the headlines, newspapers, media outlets throughout this past week. We're going to begin by talking about, finally, the establishment of what appears to be a certain trial date for one of the several criminal trials right now pending in the courts of America. This one having to do with a hush money case pending in a trial court in Manhattan. I'm going to chat with you about the decision by a judge, his name is Juan Merchan, to set that case for trial. It's a criminal case involving Donald Trump coming up in just about a month or so from now. Then after that, we're going to chat about a somewhat related matter because all these things are associated by virtue of calendars. We're going to talk about something else that happened in New York just yesterday, and that is the entry of a major civil judgment, not a criminal matter, a civil judgment against Donald Trump. And again, you have seen this as well. You know what the story is about this particular matter, a huge monetary judgment. And I'm going to offer even more than that, a significant restriction on the capacity of Donald Trump to operate as a businessman in New York. The impacts of that, I want to ask and hopefully answer the questions, why is that meaningful? And why, even in a civil setting, can it potentially be as significant, different, but significant as a criminal judgment entered in one of these other pending cases? Then we're going to spend some time also talking about other matters out there, including going to the South for a while. This hearing that was conducted over the period of the past couple of days involving the Georgia RICO prosecution, this again identifying Donald Trump and 18 other defendants in that case for their involvement in the insurrection, the attempt to interfere with the 2020 election as it related to votes and the counting of electoral votes coming out of the state of Georgia. A major 2-day hearing, an evidentiary hearing, and again, offering some perspectives on the issue of relevance. Why it is we're doing that, under what circumstances this is in court, and what the certain disposition of that case should be. Some predictions coming out of it in the wake of the incredible testimony of a district attorney now appearing on the stand to justify her personal life, if you will, in connection with the prosecution of Donald Trump. We're going to chat a lot about that and pull that apart inside Georgia law, get an understanding of why it is that that case is there in the first place, and second, talking about some of the analytics behind what the judge can and should do. Beyond that, we're going to come back to Wisconsin and talk about some major events just this past week or so involving something we've talked about before. That is the pending case in front of the Wisconsin Supreme Court having to do with maps in the state of Wisconsin. Virtually every state in the union still addressing in ways big and small issues related to in the wake of the 2020 census and line drawing. That includes right here in the state of Wisconsin, how it is that the Assembly and the Senate districts in our state will be divided up, how the maps will be drawn, significant events, legislative this past week, and perhaps some action by our governor in the coming days with respect to that could have a dramatic impact, not only upon the pending litigation, the civil litigation still pending in front of our Wisconsin Supreme Court, in the wake of the decision by that court in December of last year, finding that our present maps are unconstitutional, contrary to the terms and conditions of our own state constitution. We'll talk about the consequences of some legislative action and perhaps make some recommendations about what should happen here in the interests of justice, in the interest of ensuring that everyone in the state of Wisconsin has a franchise to exercise in the coming months and the coming years. We'll chat about all of that and more right here on our Saturday morning broadcast. A lot of things to talk about, a lot on our agenda, and welcome you once again to our Saturday morning broadcast as also. And so let us begin. Let us jump right into that first story that, again, is at the top of the news stories across our nation. We know from just yesterday that a New York judge, a civil New York judge in a civil courtroom, returned to the court and issued a major judgment, really a crushing defeat for Donald Trump in the civil fraud case, finding that the former president is indeed liable for conspiring to manipulate his net worth and ordering him to pay a penalty that on its surface is about $355 million plus interest. And that plus interest piece is all important. An awful lot of calculations today that indicate that when you add interest and other matters onto this arithmetically, this judgment will probably exceed $450 million against the former president. That coming out of a decision by Judge Arthur Engoron just yesterday, capping off what can only be described as a chaotic, years-long case brought by the Attorney General of the state of New York. Her name, of course, is Letitia James, and focusing on the wealth and specifically the valuation of properties undertaken by Donald Trump, his two sons, and the Trump Corporation for many, many years. No jury here. No jury. It is simply the judge who is entertaining argument. As a predicate to all of this, we recall well that Judge Engoron had previously found, based upon the presentation of written evidence to him, that there was no doubt that there was fraud by the Trump Corporation and by the individuals responsible for its administration. He found, as a matter of law and fact, under this summary judgment process of many months ago, that indeed Donald Trump had engaged in fraud, and for that reason, the recent trial, concluded again a number of weeks ago, was premised only upon the issue of damages. How much money would it take to restore to the people of New York the amounts that were due and owing to them based upon the misrepresentations, the lies, the accounting, not just errors, but manipulation done by the Trump organization? What is the amount of money that will basically respond to that nature of the fraud? The judge yesterday delivering this sweeping array of punishments, and we're going to talk about all of those. And it does indeed threaten the former president's business empire in ways big and small. And we will see in the course of the next 3 months and years how significant that is. But of course, all of this happens in the midst of not only the presidential campaign, in which Donald Trump is presumably not only the leading candidate for the Republican nomination, but a viable candidate to return to the White House in November. Among other things, in addition to this imposition of what is going to turn out to be about a $450 million judgment in this civil fraud case. The Judge Engoron, said this. He said that because of the facts, because of the presentations made to him by the Attorney General, largely uncontested. Yes, there was testimony, not a lot of pushback, substantive pushback, upon which the judge could rely in understanding and incorporating the defense position into his order. The judge basically said that in addition to this whopping $450 million judgment, again predicated on a $355 million base, he also barred Donald Trump for 3 years. 3 years from serving in any top role at any New York company. That is significant. That is huge. He also imposed a 2-year ban on the former president's sons and ordered them to pay, each one of them, to pay more than $400 million each. One of them, Eric Trump. You know Eric Trump. He's the company's, basically he's the de facto chief executive. And that ruling just yesterday really does throw into doubt whether any member of the family can run the business in the near term. We're going to talk more about what's happening in the past and in the immediate future here. In addition to all of this, of course, the judge had things to say about the predicates, the bases, the factual bases for his findings. And he said this. He said their complete lack of contrition, by there he means the Trump players, the Trump family members, their complete lack of contrition and remorse borders on the pathological. That's Judge Engoron releasing his opinion just yesterday about all of this. Now, undeniably, Donald Trump is going to appeal this. His lawyers have already indicated they will do just that. He's got the capacity to do it. That is a part of the due process, even in a civil case. He's got to do that and secure a bond within about 30 days or so. The ruling probably will not render him bankrupt, at least not immediately, but most of his wealth is in real estate, as we know, and for that reason, the issues about where all this money comes from loom large. The appeals court will probably also have before it a petition by Donald Trump to halt all these restrictions on him and his sons when it comes to running the company, as the appeals court reviews this in the future. In a news conference from his home in Mar-a-Lago just last night, Donald Trump attacked the Attorney General, Letitia James, attacked the Judge Engoron, calling them both corrupt. More about all of this, the significance of this civil judgment, what it means, the practical implications of it, what happens next, and other aspects of this as we continue our all-important discussion here on our Saturday morning broadcast. Continuing this morning, our exposition, our discussion, our review, our analysis of one of several breaking stories coming out of the courts of America just this past week. Initially on our Saturday morning broadcast, we're talking about this major multi-million dollar judgment entered against Donald Trump by Judge Arthur Engoron in the Manhattan trial court just yesterday. We're going to chat about many other things related to courts in America. Delighted to have you once again with me this morning as we come to you live from the studios of WAUK here on the Broadcast Service Network of Civic Media. Delighted to have you with me as we talk through this significant issue, why it's important, and what's going to happen next, and also take up many other issues this morning coming out of other courts in many ways related by virtue of timing and calendaring to what's happening in New York just this past week. Right before the break, we talked about the fundamental features of this, the headlines identifying once again what will probably end up being a $450 million judgment against Donald Trump once all of the arithmetic, all of the interest, and all of the related penalties are assessed here. Beyond just the monetary imposition, the significant portion of the judge's order also has to do with what's going to happen with the Trump organization going forward. Talked already this morning about the imposition of restrictions on future supervision for a number of years by Donald Trump and his sons. But there is even a more significant portion of this that might do a lot to have an impact upon the future of the corporation. The lawyers for Donald Trump throughout this litigation have railed against the presence and the work of what's called a monitor, a person who was appointed many, many months ago, basically to monitor and to oversee and administer the operations of the Trump organization while all this is pending. Her name is Barbara Jones. We've talked about her in the past. And the Trump lawyers have said that her work has cost the business about $2.5 million. And significantly, those Trump lawyers are upset, in addition to the amount of the monetary judgment, because Judge Engoron yesterday extended her oversight of this privately held company for a longer period of time. The judge basically said that she will continue to monitor all things related to the operations of the company, and that appointment that Barbara Jones has will continue. That also a significant portion of all of this monitoring piece, a significant consequential part of the judgment entered yesterday by Judge Engoron. The financial penalty itself reflects the lost profits, as the Attorney General indicated during the course of the presentation in this case. And about half of the $355 million, about $168 million of that representing interest that Donald Trump saved. And the remaining sum out of that total representing his profit on the recent sale of 2 properties, money that the judge said the government, the state of New York, now can claw back, basically take back from Donald Trump and the corporate entities that he owns. I mentioned already that the judge had previously found that all of this comes in the wake of fraud, and that his annual financial statements, those of Donald Trump, had not only defrauded lenders, but also accomplished this violation of basic law in the state of New York. The judge's ruling, as you read through it, as you digest it, ratified almost all of the accusations that have been brought forth by the Attorney General many, many months and even years ago. She filed this civil action claiming that Donald Trump had failed to properly evaluate and value various real estate ownings that he in fact has. And in the wake of all of this, Letitia James said this. She said this long-running fraud was intentional. She called it egregious. She called it illegal. And she said that there cannot be different rules for different people in this country. Former presidents are no exception. The reason why that is significant, of course, is because it echoes much of what we're hearing from other judges, including the judge who's right now presiding over the federal district case. Her name, obviously, Tanya Chutkan. We've talked a lot about her in the past, saying that presidents are not kings. Here we've got a prosecutor is saying presidents are no exception to the rule of law, also subject to all of the standards, the conditions, the terms of being incorporated and operating as a business person in the state of New York. As I indicated, the judge not only imposing the fine, imposing these restrictions on future behavior, but also granting Barbara Jones the continuing authority and even enhancing in some ways this monitorship that he has established previously, compliance, ensuring that the corporation is compliant with all of the touchstones, the rules, the regulations of the state of New York when it comes to financial reporting, but also other things down the road. Nothing could quite hurt as much, of course, as the financial penalty in the end. If it's upheld on appeal, it could require that the cushion of liquidity, as many people have identified, as some cash and some stocks and some bonds that Donald Trump has plainly built in his post-presidential life, could be significantly compromised. We've got a significant hundreds of $1 million punishment here. You recall as well that the court, another court in New York, another civil court in New York, in the defamation case brought by E. Jean Carroll, also brought forth and has established a judgment in the amount of $83.3 million in favor of E. Jean Carroll. That follows an earlier $5 million judgment, also based upon a defamation claim by that same plaintiff. The symbolism of all of these monetary judgments cannot be overlooked. It is undeniable that this is the latest in a series of civil cases in which the Trump organizations have been shown to be fraudulent. We know from the past that in addition to this particular finding about the core work of the Trump organization, we know as well that in mid-January, not too long ago, again, in a New York court, not identifying Donald Trump or his sons as defendants, but identifying the Trump organization as a criminal defendant in the wake of that criminal case, again, in New York. The corporation was, in fact, at that point fined $1.6 million, basically in connection with about 17 different felonies, including some tax fraud matters, falsifying business records. All of this coming in the midst of an awful lot of focus on the Trump entities. That criminal case not too long ago now joins this civil case as yet another indication of the nature, the way in which the Trump organizations have been operating for years. Going back not too far, you recall well that the Attorney General, the Office of the Attorney General there in New York, was also responsible for shutting down the Trump Foundation, again, finding that it really wasn't operating as a foundation under the rules and the regulations of the state of New York. That also a civil case stopping the fraudulent activity of the Trump Foundation. We know as well about other enterprises. For example, the Trump University, similarly, a fraudulent entity, supposedly academic and educational in nature, likewise shut down by the government in the wake of establishing factually that those organizations, the operations, are fraudulent in nature. We're going to talk more about this and talk again about the connection that this case has to the other cases that are also pending in other courts in America when we come back talking about those and the implications that this has not only today, but down the road. Stay with us for that discussion. This morning, all about this major civil judgment entered against Donald Trump, his two sons, not only imposing a huge monetary penalty upon him. We'll talk about how that gets paid, if at all, and also imposing upon the Trump players, the members of the Trump family, restrictions on the capacity to engage in supervision not only of their own corporation, but any other companies in New York for periods of years. Now, what is going to happen next? Well, we talked a little bit about this monetary penalty and this so-called bond. Donald Trump has 30 days to come up with the money. That is the amount of the judgment, or to secure a bond. And that is the case whether or not he appeals. He will certainly appeal. A company providing a bond will essentially assure the state of New York, Letitia James, the Attorney General's office, that Trump has the money to pay the judgments. And that bond would, in effect, prevent the collection of this amount while the appeal is being heard. So either you pay or you post the bond. Now, the significant challenge here, of course, is that Donald Trump has to find a company that's willing to write the bond, as he faces not only this particular judgment, but also many other legal problems. Mentioned already again this morning, this $83.3 million judgment in that E. Jean Carroll case, that following the $5 million judgment in a much related proceeding there also in New York. A bonding company would probably also charge a premium and could also require that Donald Trump pledge cash and other liquid assets as collateral. So he's got some significant financial decisions and requests and petitions to make right now to financial organizations. It is being reported widely that this is something of a test of the extent to which Donald Trump is, in fact, the multimillionaire, maybe even billionaire that he claims to be. There's no doubt that Donald Trump, in the course of his statements, certainly in the defamation case, other matters, has established he's got cash. But the judge's ruling, Judge Arthur Engoron yesterday, puts at all of that somewhat at risk. And between the defamation cases and this $450 million judgment that he will probably be required to pay now, it's entirely possible this could put some strains upon Donald Trump's financial civil status. Doesn't mean he will run out of money necessarily. He can sell one of his properties and those kinds of things. Unlikely to go bankrupt, something he has done before. But it is undeniably at this level, $450 million. More than that, of course, when you add on the $83 million, the $5 million, the monetary amount is not an insignificant aspect of the impact on Donald Trump and his organization generally. And again, the continuing monitorship, the monitor work of the monitor, this is going to be a significant matter for Donald Trump as well. Now, how did the judge calculate this penalty? Well, again, we had a trial. We had experts coming in, presented by Letitia James' office, people talking about the valuations of these properties, explaining why it is that there were certain monies not paid, undervalued properties, those kinds of things. And along the way, the evidence showed that Donald Trump and his company basically ignored appraisals, manipulated numbers to inflate the values of properties along the way. Those included things like golf clubs, office buildings, and some of those were to pretty absurd heights. And all of this is relevant because Judge Engoron reflects on this and confirms this during the course of his order of just yesterday. He describes one of the most blatant exaggerations was the listed size of Donald Trump's apartment in the Trump Tower there on Fifth Avenue. For years, apparently, the former president had valued it somewhere around 30,000 square feet value and was actually about 11,000 or so. In his ruling then, Judge Engoron blasts Mr. Trump and the other defendants. He says that misstating the apartment size was the only error to which they would admit. Goes on to say that he was not looking to judge morality, only to find facts and apply the law. And finally said the court intends to protect the integrity of the financial marketplace and thus the public as a whole. He added that Donald Trump's refusal to admit error left him with no choice but to conclude that Donald Trump would continue to commit fraud unless he was stopped. Again, shades, reflections of what we have seen in at least one other case, that is the E. Jean Carroll defamation matter. When the question before the jury there, the huge amount of punitive damages inside that $83.3 million judgment, all of that based upon an assessment by that jury, not only of the present value, the present economic status of Donald Trump, but what would do enough to punish him. What is the amount of money that would stop him from doing this in the future? And that's why that judgment, the $83.3 million, is as high as it is. Compensatory damages for E. Jean Carroll also packaged into that. But all of this focused on how do you stop someone from doing the kinds of fraud in which he's engaging, the defamation being an aspect of his misconduct, his misbehavior out there. We know, again, that all of these are civil cases. There are civil cases with the exception, as I mentioned previously, of this criminal matter, also in New York criminal court, involving not an individual, but the corporation itself. It was in that case as well that the CFO, his name is Alan Weisselberg, he had also not only testified, but also found guilty, basically entered into a plea agreement and a finding of guilt imposed upon him. His exposure there, again, 5 months in prison, also now presumably cooperating somewhat with the government as all of these cases go forward. Now, what again is the immediate impact of all this? We talked already about the financial impact, the operational impact. It's plain that the impact of this will remain to be seen in the days and weeks just ahead. But it is significant, even in the civil arena, that something of this size happens. Along the way, Donald Trump's sons, Eric and Donald Jr., also brought into this. Interesting that during the course of the trial last month, again, on the damages amount, Judge Engoron had made a comment in connection with the presentation by the Attorney General that suggested that he might spare the Trump sons from any exposure. He said, along with, what evidence do you have? I just haven't seen it that they, meaning Eric and Donald Jr., knew that there was fraud. That's the question posed by the trial judge presiding over the trial, Judge Engoron. Apparently, at some point in the last few weeks, Judge Engoron apparently saw that evidence because on Friday, he found that the sons, too, had violated the same laws that their father had engaged in. And a conspiracy to overvalue their assets generally, wrote in his ruling that there was now sufficient evidence that the judge's words that Donald Trump Jr. and Eric Trump had intentionally falsified business records, noting that Eric Trump provided the company's former controller with knowingly false and inflated valuations for one property. Again, each of those sons now on the hook for about $4 million. As punishing as all of this is, it's plainly just the prelude to what is yet to come. And we're going to talk more about that now in connection not only with this particular case, but also other matters coming up. And so let's begin to move in that direction as well. All of that civil case, that civil judgment, entered just yesterday in a New York trial courtroom in a civil proceeding. We know earlier in the week, one of the biggest stories breaking until just recent days was that in another courtroom, this one also in New York, but this a criminal courtroom, a court presided over by a judge named Juan Merchant, who has for many, many months again been entertaining, has been administering the criminal case brought by the district attorney in Manhattan. His name is Alvin Bragg. This is the hush money case. And just this past week, Judge Merchant said that the jury selection in that case is going to start on March 25th. Yes, that's right, later next month, and said that he's going to turn aside, he's going to rebuke any requests for a further delay by Donald Trump in that state criminal case, now apparently going ahead and rejecting, if you will, the requests, the petitions, the arguments by Donald Trump's lawyers that going ahead on March 25th for what will certainly be a weeks-long trial there would interfere with the White House campaign, the campaign by Donald Trump to resume his position as the President of the United States of America. The reason why this is so significant is, of course, not only the timing of this right in the middle of the coming campaign. March, again, is going to be a big month, as will all of the following months in this campaign. But it's also the first of the 4 criminal prosecutions to proceed to trial against Donald Trump and others, as we've talked about them before. Significantly, in leaving this trial date intact, actually Judge Merchant had said it previously, but was waiting to see what's going to happen with other cases, most particularly this case involving the insurrection being brought by the grand jury and prosecuted by Jack Smith in Washington, D.C. That's the Tanya Chutkan case. That's the trial that she is presiding over. That case, as you know from our previous discussions, basically suspended. Judge Chutkan took her March 4th trial date off her own calendar. Why? Because an issue raised by Donald Trump having to do with the exposure that he has under a theory, a frivolous, a non-substantive theory called executive immunity, presidential immunity, is still being resolved by the courts. And right now, the courts have not yet decided what will happen with that. In that particular case, again, much related to the New York case, the reason why Judge Merchant put this case back on his trial calendar, kept it on his trial calendar, did not erase it, was, he said, in hindsight, frankly, I'm glad that I took that position, which is, again, keeping that March 25th date in place. He said, because here we are, and the D.C. case, that is the case involving insurrection, the 4-count indictment against Donald Trump being prosecuted by Jack Smith in front of Tanya Chutkan. He said the D.C. case did not go forward. He said he decided to stick with the trial date, the March 25th date, the hush money case, after speaking last week with the judge in that Washington case. Again, her name is Tanya Chutkan. Tanya Chutkan herself, somewhat frustrated by the fact that she had to take her trial off her calendar, long scheduled for early March, while the appeals court and now the United States Supreme Court maybe going to review the appeals court decision. What is the status of that matter pending in Washington, D.C.? Well, just this past week, Jack Smith filed his memorandum discouraging the Supreme Court from taking that case, telling the court that they should permit the D.C. Circuit's opinion to remain in place, that D.C. Circuit opinion finding that there's no presidential immunity, that Tanya Chutkan was right, and permitting her to go ahead with all deliberate speed, I suspect, to try that case. That's a position taken by Jack Smith just this past week. Even so, it is still pending before the United States Supreme Court. We will see what the Supreme Court does on that case. But again, in the connection with the theme of 2024, timing and the interrelationship between all of these things, it was the pendency and the lack of a resolution in the federal court of that immunity defense, the argument raised by Donald Trump and his lawyers, the failure of the courts to resolve that more promptly, that not only prompted Tanya Chutkan to take that trial off her trial calendar, awaiting that decision, but also now, just early this past week, Tanya Chutkan and Juan Merchan talk, and Juan Merchan decides in the wake of that conversation that he is going to retain this March 25th deadline on his calendar. Again, his trial in his courtroom, a state criminal prosecution involving hush money. Significant because it will be the first of the several criminal trials proceeding to trial. Again, weeks and weeks, presumably, including jury selection. In that case, as we know as well, Donald Trump charged with 34 different felonies. And they accuse him, again, of trying to cover up the sex scandal that involved at least a couple of women, Stormy Daniels and Karen McDougal. According to all the allegations in those charges, those 34 felonies, related to the 2016 presidential election, right before that, the allegation is that a fellow named Michael Cohen, who interestingly also appeared in the fraud case involving Arthur Engeron, presiding over that case that we just now talked about, all these players, much related from one case to the next. Michael Cohen, a principal figure also now in this forthcoming trial in New York. How is that? Because he was one of the principal intermediaries at the time. He was the so-called lawyer and fixer for Donald Trump. The allegation is that through Michael Cohen, Donald Trump paid Stormy Daniels and Karen McDougal $130,000, $150,000 in a so-called catch and kill scheme that we will talk about more right after this coming break. And we are back talking this morning about all things court-related, including not only the significant judgment entered by a state court, a New York state judge named Arthur Engeron, finding that Donald Trump, again, previously finding that he was responsible for a great deal of valuation fraud, and now imposing upon him this whopping $450 million judgment. That's what it's going to turn out to be in the end when all the interest is added up. And the impacts of that upon all of the other, not only the Trump entities, but all the other trials as well, chatting in our last moments of this, the first hour, about the interconnected relationship between that case and, yes, indeed, the hush money prosecution, now apparently going to trial, likely going to trial in front of Judge Juan Merchan, again, in another New York courtroom. This is a criminal case. It's a state case. Alvin Bragg, the DA there, having charged Donald Trump with 34 felony counts of falsifying business records in connection with this attempt to undermine information, to stop information going into the public domain, sometimes called a catch and kill process, paying off these two women to keep them quiet about affairs that they had with him, he had with them. And the allegation is that by virtue of what Michael Cohen did in paying monies to them, monies gotten from Donald Trump, Michael Cohen, he will testify, was the intermediary to make this happen. By virtue of all of that, Donald Trump paid about $420,000, represented that $420,000 amount was actually legal expenses that Michael Cohen had for legal work Michael Cohen had done, when in fact, they were reimbursements, and they were not legal expenses, and that's what Michael Cohen has testified to, not only in courts, but also before Congress and certainly to investigators looking at all of this. That case going to trial now on March 25th, the first of the criminal cases. That's why that's so significant. The first of the criminal cases going ahead of all of these cases. It is not without some interest academically and in terms of law, because under New York law, the way that Alvin Bragg has charged this case is that, yes, the 34 felony counts alleging falsifying business documents premised upon New York law, but they're also premised upon violations of other laws. And he's got to identify what those specific underlying or predicate statutory violations are. And he can invoke tax law. He can invoke securities law. He can invoke other things. He can invoke federal elections laws as a predicate for his prosecution of these 34 felony counts. That, of course, is going to be a matter of argument before Judge Merchant. He has already entertained some of that, and certainly they're going to come back during the course of the trial. But it is not without its interesting academic piece, because it's not the straightforward prosecution some of these other cases are. On the other hand, many people have commented, and I will do the same, that the facts of this case are not nearly as elaborate as they are as alleged in, for example, the federal insurrection, the election interference case being prosecuted by Jack Smith, and certainly not as elaborate as the sweeping indictment brought by a grand jury in Fulton County. We're going to talk about that in our second hour this morning at great length and pull apart the evidentiary hearing in that case. Nonetheless, this is the reason why this particular case is so significant. That is the hush money case. This is in many ways the origin story, right? This is how Donald Trump in many ways came to be, because it is the first one not only charged, but also this is the one right before the 2016 election. One has to wonder aloud, if indeed this information had come forth before the election, would it have had an impact? Hard to know. Reasonable people can differ on that and make different speculative judgments about whether the impact would have been significant. But in many ways, it is the one when we first identified these activities as going to the core of our electoral process, trying to deceive the American population, the people who vote or don't vote in our elections, about what he had done in the past. That's why this case goes beyond just the 34 felony counts, whether he is convicted of those or not. It identifies this activity at the start of Donald Trump's, certainly not the start of his campaign, but the start of his time happening shortly after that in elective office as the President of the United States of America. The other cases, plainly related and unrelated, they all partake of what? Fraud, attempts to undermine the laws of America, attempts to deceive and to misrepresent, and that's what ties them all together. And so we've got, again, in the wake of all of this, the first time, a fairly certain trial date before Judge Juan Merchant coming up at about a month from now. All of that very significant in understanding all of the cases pending. We know as well, by virtue of taking some inventory here this morning, that the Mar-a-Lago case, as we talked last broadcast, continues to move apace, even where there in Florida. Jack Smith very frustrated with the presiding judge, Eileen Cannon, for her decisions to permit the production, the release of the witness identification and other information. Jack Smith challenging that in the courtroom there and potentially seeking from the 11th Circuit Court of Appeals a ruling overturning Eileen Cannon's decision on that particular issue. Could also one day prompt him to say enough is enough, and could prompt him to seek her recusal, her removal from that case, if indeed the kinds of things that she has done in that case continue to move in the direction that they have. When we review all of this in our second hour, we're going to focus a lot upon the Fani Willis case in particular, and that is the prosecution, of course, in Georgia. This multi-count indictment under RICO in the state of Georgia. As always, on our Saturday morning broadcast, we are delighted to have callers. We invite your calls in at 844-967-2789. That continues throughout our broadcast into the second hour. And we do have a caller online this morning, and we're going to take that call, and I suspect I'm going to take your call and then perhaps even answer in the start of the second hour. But let's entertain Mark's comment or question right now. Mark, glad to have you with me.
Yeah, well, thanks so much for taking my call. I mean, this all kind of relates. I mean, that Donald Trump is committed fraud. I mean, he's been adjudicated to have committed fraud, to be actually lying. And the violence that is called upon because, people, his supporters are out there, saying they're picking on poor Donald Trump. And it's kind of interesting that we heard yesterday, it's kind of a preview, that Andrew Hitt says, well, the reason we did this is because we were afraid of Donald Trump, what Donald Trump might do if we thwart Donald Trump's wishes. And this all links together in this I see this spider web of interconnecting things, his
1 FM, broadcasting to Southeast Wisconsin at 540 AM. This is The Shaw, WAUK, 0.1 FM, broadcasting to Southeast Wisconsin at 540 AM.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
This is Jim Santelle, and yes, I'm your host for this, our second hour of our discussion this morning of law and government and the aspiration for justice in America. Thank you for once again joining me for this all-important discussion or exposition of these major issues, these major events of just these past several days. As always on our Saturday morning broadcast, inviting your contributions, your perspectives, especially your questions and your inquiries about everything from procedure to law to facts. We'll try to address those. And that number, of course, to call in to the broadcast stations here of Civic Media at 844-967-2789. One more time, that's 844-967-2789. Always delighted to take your questions, your comments. Right before the break, we were talking with Mark, who is on the line still with me, talking about the interrelationship of all of these things. One of the themes of this morning's discussion, the fraud that permeates many of, if not all of these cases, civil and criminal both. And Mark, you were making that point right before the break here at the top of the hour. Why don't you go ahead and tell me more about your perspective or your question or comment about what we see recently in connection with the Trump enterprises and the Trump behaviors?
Yeah, the behavior just extends to foreign policy now and national security policy in terms of the border, because Trump says he doesn't want to see it happen, and so it's not happening as far as aid going to Ukraine, as far as fixing our border policy. That it's amazing that a man that has been adjudicated to be a liar generates such fear among some of those in the political class that they're willing to just kowtow to this man who has no official power anymore, but his power, his unofficial power, is just it's kind of scary, because that he just gives his marching orders and people are willing to die for Donald Trump. I mean, that the guy who just was found to be arrested by the FBI for lying before the FBI and lying before Congress in terms for Hunter Biden. I mean, that gets drawn into this web as well, because these people are inspired by a man who has been a known fraudster for decades. I mean, this guy, we knew he was a kind of a charlatan from years ago, but he was elected president, but now the power he has is frankly rather terrifying. If you dig down and look at it, what he could, I don't know. I'm getting a little flabbergasted now.
Legitimately so, right? Flabbergasted as we all are by this. And again, we use the word unprecedented a lot these days, Mark, but it really does apply. We've never had a situation like this where a former president has been involved in this much litigation, post-presidency, even, of course, of his presidency itself, not only in terms of criminal cases, but civil cases, an unprecedented comment, not only upon who he is, how he operates, but the other aspect of this that I think is implicit, Mark, in your comments this morning, wisely articulated and much appreciated here is just this, that Donald Trump, as he did in the wake of the Judge Engoron judgment yesterday, identified the judge as being corrupt, the attorney general also corrupt, all of the processes in all of these cases are, according to Donald Trump, accomplished by virtue of a deprivation of his due process rights. The judges are acting badly. The witnesses are not properly presenting the facts. The prosecutor is certainly at the top of the list. People who are out to get him are anti-Trump, as he often says. And, if it may well be that if one of these cases was the only one we're talking about, we might indeed look at that. We'd probably dismiss that, too, after some examination of it. But now we have all of these. And at some point, this notion that everyone out there in all of our judicial proceedings, in all of our courtrooms, state courtrooms, federal courtrooms, judges across the board of derivations on all sides of the aisle, if you will, all of them, according to Donald Trump, involved in this massive conspiracy, if you will, to go after him when, in fact, he has done nothing right. It is a difficult position to maintain. It is quite literally, as you're indicating, Mark, incredible to maintain that there is nothing here, even if along the way you identify particular aspects of some of these cases, which may or may not be proven. All of them together do, in fact, establish this practice of fraud, some of it civil in nature, as we have seen, and likely going to be proven in court, some of this criminal in nature as well. We hasten to add, as we always do on this broadcast, that any criminal defendant, like Donald Trump, in the wake of grand jury indictments, both in the state system and the federal system, presumed innocent. And it is only after a jury, or in some cases a judge if a jury is waived, only after that jury makes a determination beyond a reasonable doubt, that's the standard in criminal cases, only if a jury makes that determination beyond a reasonable doubt, does so unanimously, that presumption of innocence goes away. And that happens the moment a judgment of conviction, a judgment of guilt is returned by a verdict from a jury. And of course, appellate rights also follow that, as Donald Trump affirms all the time in these civil cases when he indicates, as he has the right to do, is going to appeal these cases to the next highest court. All of this, Mark, to your good point about the thread that we see not only presently, but in the past, presumably in the future, as we talk about all of these cases. You mentioned as well, Mark, this interesting case involving an ex-FBI informant. And indeed, it also is a part of a larger pattern about lying and misrepresenting. The story there, of course, is that a special counsel was investigating Hunter Biden, who's the son of the president, as we well know. The very same special counsel investigating Hunter Biden, also pursuing prosecutions on gun cases and on tax charges, has now charged this former FBI informant with fabricating claims. The FBI informant making up claims that President Biden and Hunter had each sought about $5 million in bribes from a Ukrainian company. And that's the statement made by this informant to the FBI, proven to be completely wrong. This longtime FBI informant, his name is Alexander Smirnov, S-M-I-R-N-O-V, is accused of falsely telling the FBI that Hunter Biden, again, the son of the president, paid a board member of this energy giant named Burisma. You've heard a lot about them in the news, and also demanded money to protect that company from an investigation by the country's prosecutor general in Ukraine at that particular time. This story again, advanced by this Alexander Smirnov, seemed to back up some completely unsubstantiated claims in the Congress, advanced by the Republicans in the Congress, of a Biden crime family. And that is the basis upon which some of the movements forward in committee to try to impeach the present president based upon this notion of criminality, things he has done wrong with his son and perhaps others as well. Well, it turns out now that based upon this latest disclosure and the indictment of this Alexander Smirnov, that those statements by him about the criminality of Hunter Biden with his father, they turn out to be completely unsubstantiated, completely false. They're simply lies. And the 37-page indictment, which again, I commend your reading of, it was unsealed late Thursday in a California court, again, brought by the special counsel. His name is David Weiss. He's the same special counsel who's prosecuting Hunter Biden now is charging this FBI informant for lying to the FBI, perpetuating this notion that the present president, his name, of course, Joe Biden, and his son was somehow involved in criminal activity. It appears as well from the indictment that the motivation for Smirnov doing this, for lying to prosecutors, for advancing this complete lie, seems to have been political in nature. During the 2020 campaign, Smirnov apparently sent to the FBI a series of messages expressing bias, that according to the indictment here, against Joseph Biden, including some texts. And they were, of course, replete with some typos and misspellings, as they often are, but boasting along the way that he had information that could put Joe Biden, but also his son, Hunter Biden, in jail. And in the wake of that initial information, Republicans in Congress attempted to get more information about this. Along the way, Chuck Grassley from Iowa released a copy of an FBI record that included this false allegation without naming Smirnov at the time, and again, without indicating that the FBI already was suspect about whether that any of this information was true and accurate. At the time, Chuck Grassley, Senator Grassley, described claims as very significant allegations from a trusted FBI informant implicating then Vice President Biden in a criminal bribery scheme. Again, all of that disclosed just this past week to be completely untrue. The course of this, again, as always, will go forward. The problems in the case, again, the underlying problems with the statements made by Smirnov are many. The FBI officials along the way plainly did not seem to think much of Smirnov's allegations from the start. 2020, they concluded his claims did not merit any continued investigation and actually told Trump administration officials in the Justice Department of that decision. And all this, again, coming out in the wake of this indictment of just this past week by a grand jury in California. The course of this, again, indicates not only the work of the special counsel there, but also the focus on the need to ensure that the information that's provided, of course, to the FBI is accurate. When it is not, that can indeed form the basis for an indictment against an individual. This matter, of course, again, the Smirnov himself presumed innocent until proven guilty. Along the way, of course, Hunter Biden still facing charges, as we know, as we've talked on this broadcast, about gun charges and tax charges, those gun charges pending in Delaware, tax charges in California. His lawyers, Biden's lawyers, saying that the indictment of Smirnov is proof that he was the target of this politically motivated smear campaign. We will see as this case proceeds through the courts, but exactly the kind of thing that Mark was describing in his comments to us of just a few moments ago. When we come back, we're going to spend a good deal of time talking about this major RICO prosecution still proceeding in the court in Georgia. Stay with us for that all-important discussion and the evidentiary ruling of hearings of just this past week.
You're listening to The Shaw, WAUK. You're listening to The Shaw,
These major cases involving Donald Trump in the state and, yes, indeed, the federal courts as well of our land, talking in our first hour about this major civil judgment entered against him in connection with the valuations charges brought by the Attorney General in the state of New York. This major case, the implications of that for the future of the Trump company and also the Trump players, the Trump family members themselves, talking as well about the significance of the scheduling just this past week by Juan Marchant, who is another New York judge presiding over the criminal hush money case that also pending in Manhattan. That going ahead on March 25th, going to take weeks to try, alleging that Donald Trump was responsible for hush payments made to women to keep them quiet, this catch and kill approach that has been the subject of a lot of reporting in the past. Now apparently finally coming to trial, the first of the several criminal cases actually going to trial. Among those cases, of course, is the D.C. insurrection, the interference with the election case. That case, again, suspended right now while the Court of Appeals and the Supreme Court itself is determining whether to take the issue of immunity before it. We'll see what happens there. The other case, of course, is the Mar-a-Lago case. That's the other federal case pending in Florida. No clear statement of when that case may go to trial, but there are proposals certainly for that to happen later in this year. A lot of activity going on there right now with related to the witnesses and some concerns that Jack Smith, as the chief prosecutor, as the special counsel, has about the disclosure of witness statements and witness information when witnesses these days are being threatened by people who identify them as appropriately being witnesses in a trial. And the concern about ensuring the integrity of the process, ensuring the safety and security of those witnesses, if in fact disclosures about who they are, where they live, what they do are made public. We know we live most regrettably, most unfortunately, illegally in a time when people threaten to do these kinds of things against witnesses. It is a concern for prosecutors to ensure the integrity of the cases as they go ahead. The other case we're going to spend a lot of time talking about this morning, pulling apart in the wake of a 2-day evidentiary hearing, is this major RICO state prosecution charging 19 individuals, including Donald Trump, many others. 4 of them have already pled guilty, 4 of them pleading guilty in front of the state court judge there in Fulton County, Georgia. The other defendants going ahead, and one of them, whose name is Michael Roman, bringing a motion to disqualify the prosecutor from future involvement, future administration oversight of the case. Her name, of course, is District Attorney Fani Willis, and also another individual in her office who was her not only a co-prosecutor there, but also someone with whom she had a romantic interest. We're going to talk more about the predicates for that. I'm going to spend a lot of time pulling apart the relevance issues that this incredible hearing of the past couple of days has presented to me, and I suspect you and many others, and addressing under Georgia law whether indeed there is any basis whatsoever for the disqualification of Fani Willis, disqualification of her office generally, under the facts as presented, and wondering aloud what the connection between the various allegations and statements and representations about finances and many, many other irrelevant things has to do with the criminal prosecution of Donald Trump in that venue, a state criminal prosecution under the RICO statute of Georgia. What is the connection between those representations that we're hearing an awful lot about in that state court and the legitimacy of the criminal prosecution, and indeed, in the end, the fact that there is no basis whatsoever, based upon the facts presented in this 2-day evidentiary hearing, to disqualify? We're going to talk about Georgia law, explain why it is that there is no there, explain why it is the relevance issue is all important, and that none of what you've heard over the past couple of days is relevant to issues that are properly before the court. Before we do that, again, we've got another caller on the line. We always appreciate your calls. Glad to have you with me this morning. Adrian, your comment or question about our subjects this morning.
Good morning. Now, Donald Trump has begun to talk about these court cases interfering with his campaigning. Now, I've had the opportunity to be in courtrooms during jury selection when a given member of the projected jury panel would try to tell the judge, look, I have to run my business, or I have a very important job, and I can't really be away from my job for this period of time. And the judge basically tells them, well, tough luck. It's a duty of citizenship, and you have to do it.
That's right.
Is it going to be the case that Donald Trump is going to be able to get away with saying that he can't participate in these jury proceedings, or they have to be postponed until after the election because of he has to be allowed to do his campaigning instead?
Adrian, that is a terrific question. It's about process, but also about things we've heard from the judges already. And you've identified sort of the distinction here between some of the things you have seen and what may go on here as well. Again, the importance between a civil case and a criminal case is important. We have seen Donald Trump, for example, come and go in the New York case. He has come and gone in the E. Jean Carroll case. Those are all civil cases where Donald Trump is represented by counsel, doesn't have to be present. And we've seen him storm in and out of some of those proceedings. And so in civil cases, he is not obliged to be there. And indeed, he hasn't always been there. Adrian, your question underscores the significant difference in a criminal case. And indeed, that's exactly why Donald Trump's lawyers are so very upset with Juan Merchan, the trial judge in Manhattan, who has set this case, the hush money case, for March 25th. Because in a criminal case, the defendant is obliged to be there. This is a situation where not only does the defendant have a right to be there, but the accused is present for those criminal proceedings. That's what, in part, in many other ways, distinguishes a criminal case from a civil case. The attorneys, again, have argued precisely, Adrian, what you've identified here, to no effect. And all the judges, at least so far, who have addressed this particular issue, including Tanya Chutkan early on, the D.C. case, the interference with the election case, have said, I'm not going to treat you any differently than any other defendant in front of me. Yes, you're running for the presidency. Yes, I appreciate you're out there doing that. But Adrian, to your good point, she has said, and indeed Juan Merchan has also said in connection with this upcoming trial, that Donald Trump, you need to be there. And it is going to make for some very interesting times in about a month from now, as Donald Trump variously is in court and also pursuing his campaign. He is obliged to be there. And while those issues will continue, certainly be raised by the attorneys for Donald Trump, they will continue to complain about this and maintain that the impacts of his being present in court are directly impacting his campaign for the presidency. My, not just speculation, my anticipation, my expectation is that all these judges will say in these criminal proceedings, that is not sufficient to remove your obligation to be here for these cases. And anticipate, Adrian, that your good question will continue to be much on the focus and the attention of judges as they go forward. And that will one day also include, of course, the Georgia case. We're going to talk more about that coming up in our next portion here on our Saturday morning broadcast. Discussion now this morning on our Saturday morning broadcast of this major RICO prosecution pending in Fulton County in Georgia, alleging that Donald Trump and about 18 other people engaged in various acts, a wide sweeping set of charges there, involved with attempting to undermine, to affect, to influence, to distort, to steal the election in Georgia based upon the legitimate votes cast by Georgia voters. A very broad indictment there brought by Fani Willis. She is the prosecutor in the case, but returned by and charged by, important point, two grand juries. One of them an investigative grand jury under Georgia law. The second one an indicting grand jury. Very important point to understand in our federal system, certainly in many state systems as well, including there in Georgia, that the prosecutor is responsible for prosecuting the charges, the cases that are returned or issued by a grand jury. And what is a grand jury? A grand jury is a group of people, typically about 25, 26 people, who are brought together from the community. They're not prosecutors. They're not necessarily lawyers who review evidence and determine whether there's probable cause to believe that a crime has been committed. And that's exactly what happened in Georgia a number of months ago. And in the wake of that review by this grand jury of the evidence in Georgia there, the grand jury returned this very broad, sweeping indictment. And in the wake of that, one of the defendants, his name is Michael Roman, he's one of the 19 charged with violations of RICO there, has brought a motion. He has brought a motion seeking to disqualify the prosecutor, Fani Willis, and yes, indeed, one of her co-prosecutors with whom Fani Willis has also had a personal relationship. His name is Nathan Wade. And Roman is seeking to have them disqualified from the prosecution of this case. And so we're going to spend some time this morning pulling apart the notion that is again, it's an applicable to cases if indeed disqualification is appropriate. But the notion under these facts that Fani Willis should be disqualified, completely unfounded, completely unsupported by what we have seen, not only in the pleadings, but especially in the hearings of the past couple of days. You know what this is all about. The allegation is that Fani Willis has brought onto the staff this fellow named Nathan Wade, and depending upon what the evidence is or does not show, the nature of the relationship, when it started, when it ended, those kinds of things, all matters of the review in the evidentiary hearing of just the past couple of days. But along the way, Mr. Roman, through his attorneys, alleging that the alleged romantic relationship between Willis and Wade, the financial compensation that Wade received as a special prosecutor, and even things like the trips, the travel with Wade and Willis while they were together romantically, that those kinds of things have an impact upon the prosecution of him, and therefore that they should be disqualified. Indeed, the entire office should be disqualified for that personal behavior. Now, let me say at the outset that I have never, as a supervisor in a prosecution office, including my 6.5 years as U.S. attorney, I have not been an especially big supporter of these relationships inside offices. Not that people can't have personal relationships, but the relationships can indeed cause problems. And indeed, there's no doubt that the relationship here between Nathan Wade and Fani Willis, which is apparently now over, has brought attention to them personally in a way that's a diversion from the principal focus, which is the prosecution of Donald Trump. And it resulted in a 2-day, a border-to-border, 8 o'clock to 5 o'clock hearing in front of Judge Scott McAfee, who's presiding over the criminal prosecution. He entertained evidentiary presentations by various witnesses, including Nathan Wade, including Fani Willis, about whether this personal relationship qualifies as a factual basis to disqualify Fani Willis and the entire office from prosecution. A couple of things related to this, and that is, number one, fundamental notion that defendants do not have the ability, do not have the capacity, do not have the right to choose their prosecutors. And as I said, there certainly are things related to the personal relationship here, maybe in other cases as well, that need to be addressed. But those are matters for internal issues inside the district attorney's office, and they do not impact and should not impact going forward with the prosecution. Let's talk about this in particular. Under Georgia law, even if all the factual allegations that are set forth about the travel, about the payments, about the nature of the relationship, all the other, I would present, irrelevant things that have been said during the course of these hearings of the past couple of days, let's assume all of those are true. There still is no basis for Judge McAfee to disqualify the office and Fani Willis from the further prosecution of this case. The key point is that regardless of those factual circumstances, the matters related to hiring and the timing of that, the relationship, all of that do not affect the propriety of the prosecution against Roman and his co-defendants, including Donald Trump. Questions, for example, about gifts, related matters go to Willis's and Wade's obligations to the DA's office. And in that connection, they have no connection to assuring the defendant, in this case, Mr. Roman, presumably the others as well, a fair trial. The allegations, the things we heard about in the past couple of days, all these facts are interesting. They are related plainly to personnel, HR, human resources matters inside the office that need to be addressed, that certainly are a diversion, that have got now the entire nation focused upon this issue and not the principal issues, which are the prosecution going forward of Donald Trump and the others. But the fundamental presentations do not have this connection to ensuring a defendant, including Mr. Roman, has the fair trial presented to him. He's got a right to that. It's not related to these particular personnel issues. There is irrelevant to the trial as allegations, for example, in other situations that, for example, prosecutors took supplies for personal use, office supplies, if you will. Let's suppose they drove some county vehicles on personal errands, even did things inside the office that relate to interactions with their coworkers. All of those are legitimate issues. They're legitimate issues for the prosecutor's offices internally to deal with, and things that need to be addressed by virtue of the oversight responsibilities of supervisors inside those offices. But those allegations, those kinds of things, personal matters, relationships, monetary matters that do not impact the most important prosecution itself, they do not affect the criminal prosecutions that require them to stop or be suspended, certainly not being dismissed, and do not justify the removal of the prosecutors themselves. Let's talk about what Georgia law says and what it does not say when it comes to prosecutorial disqualification. It's actually exceptionally narrow, and their allegations, the allegations here, do not fit in any of the categories in Georgia law under which Fani Willis could be disqualified. Again, the focus of the claims by Mr. Roman: alleged romantic relationship between Willis and Wade, some financial compensation that Wade received as a special prosecutor, and this personal travel that Willis and Wade took together, other related things along the way. Two generally recognized grounds for disqualification in the state of Georgia. The first is a conflict of interest, which we'll talk about more. And the second is forensic misconduct. What is forensic misconduct? That's doing things like going out and creating evidence that does not otherwise exist, falsifying records, suborning perjury, those kinds of things that would prompt you to say there is a real miscarriage of justice here. It would not only have you taken off the case, but probably have you disbarred, maybe even prosecuted criminally. Misconduct in terms of managing the evidence and doing things that are meant intentionally to undermine the legitimacy of the prosecution. No allegations here whatsoever of any forensic misconduct whatsoever. And so what about a conflict of interest? What about a conflict of interest? Does that exist? Well, there are such things as conflicts of interest out there. A conflict of interest, again in Georgia law, arises when the prosecutor previously had represented the defendant, for example, with respect to an offense charged. Prosecutor might be disqualified, for example, if he is a fact witness in the case against the defendant. That couldn't happen, right? A conflict of interest could happen when the prosecutor has a relationship to a victim, maybe even a member of the grand jury, that kind of thing would be a conflict of interest. Conflict of interest leading to disqualification could exist when a prosecutor is compensated by a contingency fee that is paid only if a conviction is secured, because that fee arrangement creates sort of at least the appearance of a conflict of interest between the public duty to seek justice and a private right to obtain compensation for those services. And so none of those apply in this particular case. Let's talk about those in particular and why it is that the standards under Georgia law simply do not apply, and that all the things that you heard during the course of the past 2 days are irrelevant to the legitimacy of the prosecution against Donald Trump. There is no per se rule of disqualification based upon marital status in Georgia. The Georgia Supreme Court has even explained that even married couples on opposing sides of litigation do not suffer from a conflict of interest. The opportunity, if you will, for a conflict of interest, some potential impropriety between spouses on opposing sides of litigation are greater than those on the same side of the case working toward the same outcome. And that's what you have here. You've got two people on the same side of the case, not a conflict there, but a similarity, a symmetry, if you will, of interest. There is in the end no plausible argument that non-married attorneys who are together prosecuting a case, admittedly in a romantic relationship, who serve together in this role creates a conflict of interest for the defendant, robbing that defendant in some way of their right to a fair trial. Simply isn't there. The same applies to this issue about financial compensation that Wade may have received as a special prosecutor. Likewise, those kinds of things simply do not provide support for a finding by the judge of any problem here. The financial compensation paid to Wade is frankly consistent with some well-established practices in Georgia, does not give rise to a conflict of interest warranting prosecutorial disqualification. And again, publicly available documents, part of them presented during the course of this evidentiary hearing, are indicating that Wade's compensation was not contingent, of course, on the outcome of the prosecution against Roman or anybody else. Again, that is a system that it plainly would be contrary to fundamental justice movement, that somehow the prosecutor benefits financially if indeed there's a prosecution that is successful. In all of the years that I was a federal prosecutor, state prosecutors as well, you get paid by the state, and your salary comes to you whether you are successful or not. It is not contingent, not at all contingent upon the result, whether guilty or not guilty in the criminal prosecution itself. Again, the evidence presented about the Wade prosecution, simply not relevant, not related to the legitimacy of the underlying prosecution. Concerns about whether or not somehow the issues here have been muddied in such a way that America now thinks that these are indeed relevant issues. In a related point, it's also significant that Roman's motion to disqualify also complains that Wade has never tried a felony RICO case. That's a part of his motion as well. And there again, as I said before, defendants do not have the right, the prerogative to choose their prosecutors. You can make decisions about employment that are good, bad, someplace in between. Again, those are personnel matters inside the DA's office. They may be issues for resolution by supervisors and others, but they don't have that connection, that relevant connection between what was going on inside the office and the legitimacy of the prosecution outside of the office. What is missing here of all of these cases, all these instances, including this personal travel issue, which we heard a lot about, is how, in fact, that has a substantive impact, somehow denigrates the prosecution of Donald Trump and the others, including Mr. Roman, in this case going forward in Georgia. When we come back, I'm going to make a prediction about what Judge McAfee does here in connection under Georgia law, in connection with the Roman petitions, and we'll talk about that and more right after this brief break.
The Shaw, W-A-U-K. The Shaw, W-A-U-K. The Shaw.
Continuing our analysis or discussion this morning of the evidentiary hearing that America was tuned into for the past couple of days, including the testimony of Fani Willis and her co-prosecutor, Nathan Wade, with whom she admitted she had a personal relationship, and asking the question, if not answering it this morning, of how this is relevant to any prosecution of Donald Trump, which does proceed, and most specifically, under what rubric, under what structure does any of this information about the financial relationship between them, the personal relationship between them, the compensation of Mr. Wade, all of that, what is the relationship between that and a reason to disqualify the prosecutor in the prosecution itself? The answer is that there is none under Georgia law. There is nothing about the forensics of this. There's no conflict of interest. There are no two interests that are conflicting here. Instead, there is simply allegations and perhaps even proof of personal relationships inside the office. Those do not affect the legitimacy of the prosecution going forward. And those of us listening and watching, including you, to the evidentiary presentations of this past couple of days, had to be scratching our heads collectively saying, what is going on here? If the judge is, in fact, simply attempting to make a full record for Donald Trump and for Mr. Roman himself, giving them the full opportunity, as he said once, to present your case, that is one thing. If, on the other hand, the notion is that somehow there is a legitimate, there's something real here, this is a legitimate argument to make, the answer is no. This is nearly frivolous in terms of its presentation, and anticipate that Judge McAfee will soon, hopefully very soon, issue an order finding that none of the evidentiary presentations, while interesting, may be salacious, may be appropriate for coffee table conversation about what's going on inside the office, do not, in fact, constitute a conflict of interest for Fani Willis or her office that in any way deprives either Mr. Roman, Mr. Trump, or any of the other defendants of a right to a jury trial, right to a prosecution that is free from interference from anything that is inappropriate or wrong. That's simply not here. And so under Georgia law, as we have described it, all these things make clear that while this process perhaps had to be conducted as a part of the pretrial proceedings, it has been, as many people have said, a sideshow, a collateral issue, a footnote to what should be the focus, which is the substance of the prosecution as it goes forward. We hasten to add once again, Donald Trump and Mr. Roman, other people in this case who have not yet pled guilty, the presumption of innocence stays with them as it will, as all of this goes forward. Anticipate that Judge Scott McAfee hopefully will make short shrift of this, issue an order, perhaps an oral ruling, maybe a substantive written ruling about all this, but should come to a conclusion fairly soon. All of this, of course, a diversion, and also taking time away from the actual work of prosecuting and defending this case pending right now in the Georgia court. Find this morning some commentary about Wisconsin itself, coming right back home. We know from our previous discussions way back in December 22nd, our Supreme Court overturned the current maps that are existing for our recent elections here in the state of Wisconsin for the Assembly and the Senate, and ordered that parties propose new ones. The vote on that decision was 4-3. And in the wake of that, the court hired some academic consultants to analyze those proposals for new maps. It directed the parties on both sides to file memorandums of law, and all that has been going on. Lots of briefs and responsive briefs. All of that has come to a conclusion. Along the way, the consultants found that the plans offered by some Republican lawmakers and by a conservative policy group constituted partisan gerrymandering and should not be considered. The four remaining proposals, greenlit by the consultants, were submitted by the plaintiffs, by the office of the governor, by Tony Evers, by some Democratic senators, and also by some mathematicians and data scientists. So we've got lots of maps out there. And the Wisconsin Supreme Court, again, has taken all of this, if you will, under advisement, based upon its commitment, as I said before, that if the legislature and if the governor cannot come to an agreement on their own, as they should under the normal process, then the Wisconsin Supreme Court will take this on, and based upon all the submissions, including the maps, including the statements by the lawyers, when all of that happens, they will then issue their opinion. Well, something significant happened this past week, as you have heard in the news, as you know, right here on the newscasts of Civic Media, and that is that just this past week, the legislature, led by the Republicans, adopted the voting maps that were drawn by the office of the Governor Tony Evers. And Tony Evers has said, of course, that he would sign that redistricting plan. It was passed unchanged. And earlier on, there was a bit of a skirmish about whether or not the plan, an earlier submission, did in fact constitute the governor's plan, the governor's maps, or if it went in fact accomplish some changes in that. It's very clear now that just this past week that the legislature passed the governor's maps themselves. And so the question now is, will the governor now sign this while this is pending also before the Wisconsin Supreme Court? Plainly, the governor's indicated that he intends to sign it. We'll see if he does that. Anticipating that he does, it is also significant to note that even under the new maps, the maps that he may have presented, that the Republicans will still retain some majorities in both chambers, though the party's advantages would likely be similar than the absolute authority it now sort of commands, particularly in the Senate. And so the net impact of this, even with the governor's plan, may not be to shift power and responsibility inside the Senate and the Assembly, but nonetheless make the maps more fair in Wisconsin. The governor should sign that map. And I know that there is some concern among some members of the legislature, particularly on the Democratic side, about the possibility of getting an even better map from the Wisconsin Supreme Court. And I will say simply this, that in all the civil litigation, which this is, fundamental notion that if you can settle a case, bring it to resolution, which this would presumably for the next 7 years or so, always better to try to resolve a case outside of court, even though if everybody gives up something, the Republicans and the Democrats give up something that they would otherwise have, probably a good result if everybody walks away with a settlement with which they're somewhat a bit unhappy. Common phrase, common adage out there in the civil litigation. And so we would anticipate the governor would bring this to a conclusion, the Supreme Court then not having to decide this issue. And America would look to Wisconsin and say there's a situation where the legislature and the governor did their jobs, fair maps in place for the at least remaining 7 years of our time. Next week, as in every week, we continue to focus on these issues of courts in America, American justice, government, and the aspiration for justice in Wisconsin, in our nation. Come back again next week for that important